Ms. Reilly, you may proceed.
May it please the Court. Courts have unfailingly applied the unequivocal intent standard when construing legislative contracts. This standard is critical to the public welfare because it ensures that the sovereign power to set policy and change laws is not surrendered inferentially, implicitly, or inadvertently. Because the stakes are so high, the derogation of the sovereign power must be unmistakable. The unequivocal intent standard applies with special force where the interpretation of the contract that plaintiffs urge would result in a drastic limitation on the power of the state, the power to enact a legislative remedy to address a problem in which multiple stakeholders and the general public have a vital and competing interest. Here, the legislature sought to preserve the pension funds for the benefit of all employees, active and retired alike. The non-forfeitable rights statute does not even mention COLAs, much less create an unequivocal contractual right to them. In construing public contracts, silence is negation and doubt is fatal to the claim. And the most obvious, common sense meaning of the laws governing PERS is the PERS Act, not the entire 3 volumes of Title 43. This interpretation is borne out by Section 1 of Chapter 113, which lists the same 7 retirement systems and includes a citation not to the entirety of Title 43, but rather to the acts that established PERS and the other retirement systems. The substantive COLA laws, however, are not in these acts, but are in a separate statutory scheme altogether. We believe that this interpretation is the definitive one, but even if this court believes that the state's textual analysis yields only a probable or even possible interpretation of the non-forfeitable right, the state still prevails because under the unequivocal intent standard, any ambiguity dooms plaintiff's claim. And it is of no avail for plaintiffs to stake their claim in the phrase benefits program. Such a general, open-ended, undefined phrase is precisely what the unequivocal intent standard prohibits. If this were an ordinary statutory construction case, plaintiff's argument might be plausible enough to prevail. The court would do its best to discern legislative intent, and if it got it wrong, the legislature could enact a statute clarifying what its intent had actually been. But this is not an ordinary statutory construction case, and no such opportunity exists here. The court's determination of the scope of the non-forfeitable right will be set in stone forever, unalterable, and the sovereign power will be diminished, unable to be regained. For these reasons, the law requires precision, unmistakability, and unequivocal intent. Nothing less is sufficient to safeguard the public's right.
Have you concluded your opening statement?
Yes, Your Honor.
I know we started with some lofty, important arguments. The clerk, however, mentioned that you wanted to reserve time for rebuttal. Did he get that right?
Yes, Your Honor.
All right, I'll mark you down for that. Your adversary tells us that the phrase laws governing the retirement system or fund does indeed encompass COLAs. Can you expand on your argument as to why that's not the case?
Excuse me, Your Honor, I didn't hear you.
The phrase in the non-forfeitable rights statute, laws governing the retirement system or fund, you argue ties into the principal retirement fund statutes and not the PAA, not COLAs. Can you expand on your position?
Yes, Your Honor. The state's position, which ties the phrase benefits program in subsection A to the phrase laws governing the retirement system in subsection B, and then roots that in section 1 of chapter 113, which lists the retirement systems, and then cites to the laws establishing the act. The state's interpretation is the only one that both preserves the unequivocal intent standard and gives meaning to the non-forfeitable right standard, to the non-forfeitable right.
So let's try to drill down a little bit as to what that means very specifically. If someone is in the system and reaches the age and service requirements, let's say take PERS, has reached age and service requirements, is it your position that that cannot be changed?
Yes, Your Honor. The state's position is that it is the retirement allowance and benefits that are established by the PERS Act itself that are protected by the non-forfeitable right, and that includes the formula, the person's annuity plus interest, the retirement allowance that cumulatively result in a pension that's times by a fraction of the compensation.
Now for someone who's been in PERS and has retired, and has been retired for a period of time prior to 2011 and received a COLA. And that COLA now, is it your position, becomes part of the retirement allowance, which cannot be reduced going forward?
Well, Your Honor, 2 points there. Just to make sure we're on the same page, the COLA is always separate and distinct from the retirement allowance.
And it can, and over periods of time, I realize that sometimes there's a formula for calculating it according to the CPI, and that over time there have been times when the legislature has determined what percent of the CPI will be the COLA. But if someone has retired and they've been retired long enough to qualify for a COLA, and they received that, is it your position that that person's retirement allowance is now the basic allowance pursuant to their system, with the addition of the COLA they received?
Your Honor, I think that presents, and I hope I'm answering your question, I think that presents an analytically distinct question. Here, what the state did was say that the person is going to continue to receive the retirement allowance and the COLA frozen at 2011 levels. So their benefit is not being reduced in any way. The person is still receiving 60% of the difference between the CPI in the year they retired and 2011. What the state has done here is say that going forward, post-2011, there will be no increase in that level of COLA based on changes in the CPI. The state here is not reducing anything that retirees have already received. That, I think, presents analytically distinct questions about property rights and things that are not at issue.
But I'm just, as I said, trying to actually put it in very concrete terms. If someone had retired and had a retirement allowance at retirement of, say, $1,000 a month, and over time, because of COLAs, in 2011 was receiving $1,100 a month, that it cannot be reduced.
That, Your Honor, is what the retiree is still receiving, and whether or not that can be reduced is not at issue in this case and entails an entirely different analysis. What the federal government has said in the Zucker line of cases is that once a COLA is received, as you just indicated.
It's essentially, it attaches.
Right. Well, once it's received, and so the $1,100 level, what the federal government has said that once it's received, then there may be sort of property rights that kick in. But until it's received, the Congress is okay to freeze it going forward and not give any additional.
So the
COLAs.
state is not, is taking the position that, as I said, that now $1,100 that was being received cannot be reduced.
Your Honor, we're still saying that the non-forfeitable right does not include COLAs, even COLAs that have been received. However, whether or not that could be reduced below 2011 levels, I mean, that's an issue that we would have to brief and discuss. But it's not what's happening here.
It's not what's happening here. Okay.
So you're not, just so I'm clear, you're not even willing to concede that the COLAs that have been attached to the salaries of retirees from 1997 to 2011 cannot be reduced? You're not willing to commit that? Are you suggesting that that the retirement amounts that retirees are receiving today cannot be reduced? You're not willing to commit to that?
Your Honor, what I'm saying is the COLAs, even after they are granted, do not somehow become part of the non-forfeitable right. And what I'm saying is that presents analytically distinct issues which the state has neither thought about nor briefed. What we have here is there is no reduction because retirees are still receiving the amount that they've always received.
I'd like to look at the plain language of the statute for a moment. I'd like to do that because the people who are employed by the states and municipalities rely on this language to govern their affairs. So 43, 3C 9.5, the B employee shall have a non-forfeitable right to receive benefits as provided under the laws governing the retirement system. That's pretty broad language. Would you agree?
Your Honor, I think the phrase laws governing the retirement system has an element of precision. It's the laws governing PERS, the laws governing PFERS. And the PERS Act itself the PERS Act says in the definitional section, PERS, the corporate name for the retirement allowance and other benefits established by this Act.
I'm looking at the language of this statute. Why wouldn't any reasonable person, and that includes all the people who decided to retire based upon their reading and understanding of this statute, not think that under the laws governing the retirement system would also not include the laws that are applicable to COLAs, okay, which apply to our retirement system? Why wouldn't they think that, particularly when you look at A, and the only exclusion for post-retirement benefits are medical benefits, not COLA benefits?
Your Honor, the legislature included the expressly excluded medical benefits in an abundance of caution to ensure that the state's pension systems retained their qualified status under the Internal Revenue Code. The whole purpose of Chapter 113 was to demonstrate that the state's pension systems conformed to IRC requirements. And under the IRC, medical benefits can be part of a qualified pension plan, but only if the medical benefits are subordinate to the retirement benefits.
So I understand you. I'm looking at the plain language. Forget about looking at the legislative history, okay, and all the rest. The plain language of the statute. Why does it not suggest, and even more powerfully suggest, that these COLAs are benefits, particularly since medical benefits are excluded, and the language of benefits is general.
Your Honor, 2 points. One, the unequivocal intent standard. Under that standard, general, imprecise language is not enough. And secondly, even the legislature that enacted the non-forfeitable right did not recognize COLAs as being part of that. And let me explain a moment. In 1969, the legislature amended the Pension Adjustment Act, 43:3B-8, and it said that should there be a blanket increase in pensions, then COLAs shall terminate thereafter. And 6 months after it created the non-forfeitable right statute, in December of 1987, the legislature enacted Chapter 281. And Chapter 281, which is codified at 8.5 of the Pension Act, exempts firemen from this COLA termination provision. So how could the legislature that enacted the non-forfeitable right think that it had created a contractual right to COLAs and then 6 months later say, oh wait, we need to exempt firemen from the termination clause? If the firemen had a non-forfeitable right, then there would have been no need
These things
to do
happen.
Does
that.
Section E of the statute inform your argument at all?
Excuse me?
Does Section E of 43:3C-9.5, Section E, does that inform your argument at all? Where it
Yes.
says that nothing in this act shall be deemed to limit the right of the state to alter, modify, or amend such retirement system and funds? Does that inform your argument or play any part in your argument?
Yes, Your Honor. As this court has said in Barcelona and other cases, subsequent legislation can be a great tool to see what the original legislature meant. And here, the same legislature that enacted Chapter 78 included that language you just said that the state's ability to modify cannot impair the contractual rights so listed. Yet that same legislature in Section 25 froze COLAs at 2011 levels. So the legislature could not have intended, that legislature at least, is saying that it understood the 1997 legislature to be saying that COLAs were not part of the non-forfeitable right.
Your adversaries are citing the principle of statutory construction that states that when we have a remedial statute, it should be liberally construed. And obviously that's a commonly invoked principle of statutory construction. Is that negated by the principle requiring unequivocal intent?
Yes, Your Honor, I think it is, because the liberal construction canon applies in the cases that they've cited. They're non-contract cases, and they don't really impact the sovereign power because they deal with one or a handful, at most 100 employees. The unequivocal intent standard is for contracts, legislative contracts.
But we do find in contract cases some statutory construction principles that are more broadly applied have a place in those cases, do they not? Not necessarily this one, but other principles of statutory construction.
Your Honor, I think with legislative contracts, courts have unfailingly applied unequivocal intent. And I think that where you're dealing with pensions, a third canon of statutory construction is relevant, and that is that statutes must be construed so as to preserve the integrity of the pension funds, as this court did in Jacobs and
But do you,
Fairlawn.
in order to get at the answer as to whether there is unequivocal legislative intent that's found in a statute, do you employ the normal range of principles of statutory construction to determine whether there's that legislative intent?
No, I don't think you do, Your Honor, because I think that the normal canons of statutory construction allow for inference and implication, and here it has to be unmistakable so that there's no need to employ any other interpretive canons.
Well, don't we presume that the legislature understands our canons of statutory interpretation? So I'll just apply one, which is revealed in the Prado case. So when you look at A, you have a general clause that says non-forfeitable rights to receive benefits means that the benefits programs for any employee cannot be reduced, ... That's a general provision. And then you have an exception. The exception is it shall not apply to post-retirement medical benefits. We have a canon of statutory interpretation that says that general provisions shall be construed broadly and exceptions narrowly. So applying that canon of statutory interpretation, narrow interpretation of the exceptions. Medical benefits is stated there. That's the exception. The general provision, broadly read, that says that benefits program would include benefits such as COLAs, things that were applicable in 1997 and that the now retirees were receiving. Like, why wouldn't that canon of statutory interpretation apply?
Your Honor, that canon flips the unequivocal intent standard on its head. It's not what's expressly excluded. It's what's precisely and unmistakably
So are you suggesting
included.
that every canon of statutory interpretation goes by the wayside? Because if they're applied in a way that doesn't work to the advantage of the state, it's not in conformity with your unequivocal intent?
No, Your Honor, I'm saying that the overriding dispositive canon of construction is the unequivocal intent standard. If benefits program meant all laws governing the retirement system, then you're faced with Title 43, which is 3 volumes, 2 volumes of which are dedicated to pensions. Did the legislature intend to include the provision that said, and the PERS Act, the acts themselves that established the system, are only a tiny portion of those 2 volumes. Did the legislature intend to include...
How do you think normal people read this? How are, like, the citizens of the state, the employees who work for the state and municipal governments, supposed to guide their lives if they cannot read a statute and expect the plain language of the statute to rule the day?
Your Honor...
Do we expect them to go through, thousands of pages of legislative history to try to divine the intent of the legislature when the plain words seem to indicate something else?
Your Honor, the most obvious common sense meaning, if someone said to me, give me the laws governing PERS, I'd hand them the PERS Act. I wouldn't hand them all 3 volumes. The language is plain. The laws governing the retirement system.
Do you not think that a COLA is a benefit?
Your Honor, even if a COLA is a benefit, that's irrelevant to the question of whether the legislature intended to include it within the laws governing the retirement system. If the laws governing the retirement system is read super broad to include everything, including all those benefits outside of the PERS Act, there's no limiting principle. Unequivocal intent is gone.
Let's turn back to the plain language of the retirement system statutes themselves, because your adversaries point out that in many, but not all of these retirement schemes, there is a reference to the pension adjustment benefit. And you address that by saying that it's addressing only funding, not any substantive right to the allowance. Can you elaborate on that, please?
Yes, Your Honor.
Working from the exact text of the language that appears, I'm looking at the PERS statute right now, 15A-24.1.
Yes, Your Honor. That provision does not create a substantive right to COLAs, but rather only provides the procedural mechanism to fund them once the state had switched from a pay-as-you-go to a pre-funding mechanism. If, as plaintiffs allege, that did create substantive rights by simply mentioning the Pension Adjustment Act, then it would run afoul. There's 3 things the court would have to ignore in order to accept that interpretation. The first is Article 4, Section 7, Paragraph 5 of the Constitution, which expressly prohibits that sort of incorporation by reference. And that provision goes back to 1875 and the Constitutional Commission. And at that time, so many laws, almost half the laws, contained provisions like, oh yeah, reference to this, reference to that, that no one knew where the substantive laws actually resided. And all sorts of questions arose. Well, if I repeal the original law, is it still alive because it was referenced in a bunch of other laws? And that's the genesis behind saying, no, you can adopt by reference procedures in another law, but you can't adopt the substantive rights wholesale. And this court said that in the Port Authority of New York case. And second, the language itself that you asked me to focus on. The language itself draws a dichotomy, recognizes a distinction. It says pension adjustment benefits for members of, I have the TPAF here, Teachers Annuity Fund, as provided by the Pension Adjustment Act. And then at the bottom it says, it makes a distinction and it says basic retirement benefits provided by the retirement system.
I noticed that as well. Your argument and your brief seem to focus on the nature of pre-funding, not changing the nature of the benefit, and I didn't know if you were going to rely on this seeming legislative distinction between basic retirement benefits provided through the retirement system and pension adjustment benefits provided through a separate statute.
Yes, Your Honor.
You are relying on that.
Yes, and the third reason why plaintiff's argument doesn't prevail is because, as you mentioned, only 5 of the retirement systems contain this language. The Prison Officers Pension Fund and the Consolidated Police and Fire Pension Fund do not. They remain on a pay-as-you-go basis. And there's no indication in the non-forfeitable rights statute that the legislature intended to treat the 5 systems different than the 2 and to give the former more benefits or different benefits than it did the latter.
So you don't think the fact that they refer to it as a liability of the system changes anything? Forget how it's paid. The fact that the legislature chose to call pension adjustment benefits a liability doesn't change the nature of the benefit?
No, Your Honor. That's for actuarial purposes in terms of how the annual required contribution is going to be calculated, and that it doesn't transform the nature of a benefit into a contractual right is evidenced by 2 things. One is that the state health benefits program, there was originally this identical language for that, and then in 2007 the state switched that out and went to pay-as-you-go. And the base pension benefits themselves 50 years ago went to a pre-funding method, yet nobody's claiming, everyone's claiming that it wasn't until 1997 that the contractual right to base pensions came into being. So the fact that it's a liability...
Ms. Reilly, if we were to agree with your adversaries that the COLA was part of the basic pension benefit and that it could not be eliminated once the non-forfeitable right came into being, would that argument taken to its logical conclusion mean that even before the non-forfeitable statute was passed, the COLAs could not be altered by the legislature? Once having been given, they could not be taken away?
Just to make sure I understand the question, if the court were to find that there were a contractual right to COLAs, then I think one of the questions, assuming there would still be a remand after the potential ratification of the constitutional amendment concerning the non-forfeitable right, but assuming that a remand were still going on, I think you would have to, one of the things the remand court would have to answer is, when did the contractual elements attach, the offer and the acceptance? And there'd be a bunch of classes there. Did folks who retired before the switchover from pay-as-you-go to pre-funding, did they have the contractual right?
You misunderstand my question.
I'm sorry, Your Honor.
My question is, I'm trying to understand the breadth of the argument of your adversary and, of course, your response to it. If they're right that once a COLA statute has been passed, it becomes part of the retirement benefit, and therefore employees who take life action in reliance on that are entitled to rely on it into the future, does that make the passage of the COLA statute that we're looking at now, the current PAA, something that could not have been amended by the legislature, regardless of whether there had been a non-forfeitable right statute enacted.
Yes, Your Honor. I think the logical conclusion of their argument seems to be once a COLA, always a COLA. And that argument doesn't account. And if that's true, why did you need the non-forfeitable right to begin with? And I think that argument does not address the fact that the COLAs have been amended at least 14 times since they were initially established.
Accepting that premise, there's nothing that would stop the legislature from amending prospectively for new employees, no?
Correct, Your Honor. And I think they did that in 2010, Chapter 2, when they amended the non-forfeitable rights statute to say that for new employees going forward, there is no non-forfeitable right.
So what do you say to the thousands of employees who say that they relied on this statute to retire early, believing that they would receive COLA benefits based upon the broad language? Benefits are COLAs. Even as we're talking, I'm listening to discussion over here. No one seems to be saying that a COLA is not a benefit. So what do you say to those people who said we looked at the statute, we read the statute, we relied on the statute, we were retired based on the statute?
Your Honor, I'd say two things. One, I'd say that there's no misrepresentation of material fact because there is no unequivocal promise here. And two, I'd say that any reliance is not reasonable because this court has long said that legislative directives are not representations upon which folks can rely. And the court has also said, just impairment jurisprudence, that even contractual rights can be impaired if it's reasonable and necessary. And in Gower and Spina, this court said in Gower, pension benefits can be modified in the interest of assuring the integrity of the pension system, which is what happened here. And in Spina, the court said even if the employee's pension rights stemmed from a contract, there would be little doubt of the legislature as to the power of the legislature to rewrite the formula for the good of all. And that's exactly what has occurred here. In a quintessential legislative decision where there's multiple stakeholders with competing benefits, the legislature sought to balance the rights and burdens for all the stakeholders.
You cited a number of out-of-state decisions from other jurisdictions as supporting the application of the clearly indicated or unmistakable standard. Are there any cases that use anything other than that standard that you are aware of?
Your Honor, and I'm not sure if it's a different standard or not, but I think there's a case called Morrow out of Oregon, which interprets its contract clause on the basis of the contract clause as it existed in the U.S. Constitution in 1857. And I do not think that in 1857 the cases required the unequivocal intent standard. We first start seeing that language by 1880. The courts are saying that language, that standard has been established for a long time, but we don't see where it started. Every other case, federal, state, has applied the unequivocal intent standard, and in pension contract cases.
Mm-hmm. Thank you.
Other questions, anyone? Is there anything you'd like to add?
No, Your Honor.
We'll have you back for rebuttal.